then that we're tracking right now. Shapoorji versus Tata legal battle is expected to begin in a few days. That's what our sources are telling us. The Shapoorji is possibly going to use a section of 397 of the Companies Act, the section on oppression of minority shareholders. Latha has all of these exclusive details and is here with us to take it away. Latha.
Well, it's quite clearly a May Day or a Diwali for the legal community, because both sides can hire big lawyers, and what we are getting from the legal fraternity is that Shapoorji Pallonji will approach the company law board. Even if the case has been filed in the Mumbai High Court, there will be a case filed in the company law board where Shapoorji Pallonji will press the section 397 of the old Companies Act. There must be a concomitant section in the new Companies Act, which I don't know, but that section is called Oppression of Minority Shareholders and Mismanagement Clause, and they will also ask the public trustees of the various charitable trusts not to vote. This is a very interesting ploy that I picked from the legal community. The various charitable trusts, there are a lot of charitable trusts who on behalf of their charities have voting rights in many companies, and normally their vote is not cast by their own members but by a public trustee, an IAS officer, a charity commissioner, someone appointed by the government. Now the Shapoorji Pallonji group is going to tell them not to vote in favor or vote along with the management, in this case the Tata Sons. Normally the charity commissioner does not even attend and will not vote. In well-run companies, all they want is the dividend. The charities only want the dividend. But in this case, Shapoorji Pallonji will prevail upon them to actually abstain from voting, so that there is a true strength of test between the Pallonji families and the other shareholders. That is why Ratan Tata had to write a letter to the Prime Minister. Otherwise, there was no place where the government would be involved. It is because there will be a public trustee appointed to the charities who will definitely be approached by the Pallonji group. That is why this proactive letter from Ratan Tata to the Prime Minister explaining his stand or whatever else the letter might contain. Lawyers for the two groups are the best and the brightest of the legal fraternity that you can possibly think of. Rayan Karanjawala, one of the foremost legal companies in New Delhi, and already a lawyer for Tata Steel, will be fighting on behalf of the Tata Trusts. They have also engaged, as Arun Giri told us yesterday, P. Chidambaram and Kapil Sibal apparently has also been approached. Meanwhile, Cyrus Mistri's case is definitely going to be fought by Iqbal Chagla, who is his father-in-law. Iqbal Chagla's junior, Jalak Dwarkadas, will obviously be in the fray, and we understand that Somshekhar Sundaresan has also been approached by the Cyrus Mistry camp. Notable people who will not be fighting the case will be Harish Salve and Manu Singhvi, who have been approached by the Tatas with a negative brief, that is paying a retainer to not fight on any side. So they will perhaps sit out in the case. These are news that we are getting from the legal fraternity, legal sources actually. So what we are seeing ahead is a 1 to 2 year battle under 397 clause of section of the Companies Act. This is not a battle about you didn't give me 15 days notice before removing me, or the item of my removal was not on the agenda when the agenda was first presented to shareholders. It is not as minor as that. The fight is quite clearly for the 18.5% of Tata Sons, which if valued by a valuer would come to several thousands of crores of rupees. So it is now to protect their wealth.
That's just one point. Who is the end beneficiary of these trusts? And I think for this, to answer that question, we'll have to go back to the family tree.
We have to go to the family tree.
It gets complicated.
Exactly. Yeah. Obviously, a lot of the dividend will be paid out to several Tata families who will also be other shareholders. I mean, the trusts are Dorab Tata and Ratan Tata are some of the trusts that are holding.
No, so when you say that,
there will be non-trust shareholders also of the promoter family.
Correct. No, when you say that the Pallonji group will try to prevail upon the trust not to kind of abstain from voting when the issue comes up.
So we have to find out what is the non-trust voting remainder vote in the Tata Sons board as well. But separately, the fight is obviously for that 18.5% stake and its value. And in the process of invoking Section 397, what the Pallonji family is expected to do is to unearth a lot of dirt, point out to several actions taken by the Tata group of companies, saying that public interest and minority interest was not served by the Tatas, and they could invoke the Docomo case, they could invoke the Chorus case, they could invoke the purchase of Welspun's solar power unit. All that is now in the public domain. Any of these could be invoked to to point out that the minority shareholder's interest was not protected by the majority shareholder. So what we should probably see is a lot of dirt getting washed in public. It is not going to be anything as simple as you did not give me 15 days notice.